Good evening, everyone.
Good evening to you.
Good evening. Good evening. So this Sabha, and we'll begin another.
I'm to change my virtual background. You requested me to change the virtual background. I'm just doing that.
I'll request both Sarah in virtual.
Is the virtual background okay now? How do I apply this? You told me yesterday, I thought.
We'll briefly see a video of how this Gyan Sabha has evolved over the past couple of months. Although DIYA Mumbai was conducting an annual program every year, but then the pandemic has forced us to go to technology, resort to technology, and in fact, it has provided us with a better platform to call different people from all walks of life who come on this platform and share their views on things that matter to the citizens, things that are important in contributing something to the society and the nation as such. So we'll briefly see a video before we commence today's session. So once again, I welcome everyone who has joined us on this session of Gyan Sabha today. As we could see in that video, Gyan Sabha is a platform, it's a thought platform for thought leaders. People from different walks of life, be it science and technology, be it law and judiciary, be it medical profession and doctors, art and culture. People from these fields have come on this platform over the last 6 months, each Sunday at 4:30 p.m. and they've shared their views on things that matter to us and things which we can take up and make the society and make the nation a better place. We are indeed delighted to have with us today Shailesh Gandhi ji, who has done immense work in the field of information, right to information, that is RTI, Suchna Ka Adhikar. And it's my pleasure to read out his profile to our viewers today. As I mentioned, Sir has done path-breaking work in the domain of RTI, and it's an initiative which is for citizen empowerment. So he's an alumnus of the IIT Bombay, former information commissioner with the CIC, that's the Central Information Commission. And while he was the CIC, he gave many landmark decisions on RTI apart from organizing first digital paperless office in the commission. He was a part of the national RTI movement, which was involved in drafting the national act, that's the RTI. He was convener of the national campaign for people's right to information. He has used the RTI and also treated many citizens and government officials in over 1,000 work. And he has published a book, RTI Act, Authentic Interpretation of the Statute, and a paper critiquing Supreme Court judgments on the RTI. Sir has been a recipient of the prestigious Nani Palkhiwala Civil Liberties Award and the MR Pai Award. So quite a prolific profile, and who better to talk on this topic of right to information than him. So I extend a very warm welcome to you, sir, today on this platform of Gyan Sabha. And it's indeed a pleasure having you. Very briefly, without taking much time, I'll set out the context of today's webinar. and what DIYA does, what sort of activities does DIYA do. So Divine India Youth Association is a concept which was formulated way back in 2006 by late President Dr. APJ Abdul Kalam, and Dr. Pranav Pandyaji was the Chancellor of Dev Sanskriti University at Haridwar. When these two thinkers met in 2006, they thought there is a need to provide a platform to the youth of this country, which amounts for almost 65 to 70% of our population, a platform where they could channelize their energies and do something constructive. So all the volunteers of DIYA, including those who are present today, are people from different walks of life. They are scientists, or they are working in the IT sector, lawyers, engineers, chartered accountants, academicians, who take time out of their professional and personal lives and do these kinds of activities. And in wake of COVID, it has in fact handicapped us to go out physically and do activities. So we thought it would be better to take this platform on a virtual plane, and this is how the digital Gyan Sabha platform evolved. So that is the context, sir. And we also, on Gyan Sabha, apart from taking up specific topics, we do take up topics which are directed at citizen empowerment. For instance, we had Justice Sri Krishna speak about what are the rights and duties of a citizen in nation building, and things like that. So it's a platform where people from different thoughts converge, and people from all walks of life come, and they try to figure out how best we can utilize our time, our resources, and our capabilities in some sense apart from our professional engagements to contribute something. So I once again welcome you very warmly, sir, and you agreed to come on this platform and share your thoughts on RTI. So without taking any further time, I would request you to please address us on today's topic, and I'm sure it will be an eye opener for common people on how to use the RTI as something to to empower ourselves and to do things which we wouldn't be otherwise able to do, but for this wonderful piece of legislation, which may have its pros and cons, but it's a start nonetheless. So I welcome you, sir.
Thank you very much. Fellow citizens of India, I am very grateful that this platform has given me the opportunity of interacting with all of you. And DIYA is a very good name for spreading knowledge. And I think they're doing a wonderful job of it, and I congratulate them, and I'm happy to be part of this. We say India is the world's largest democracy. Democracy, I was taught in school, is rule of the people, for the people, by the people. The truth is, no average citizen of India feels like he's ruler of this nation. In fact, if an average citizen goes to a government office, he or she comes out feeling angry, frustrated, and humiliated. Then how are we a democracy at all? We say we are a democracy because we have a reasonably fair system of elections by which we are able to change governments and leaders and members of parliament and our representatives. I would submit to you that that by itself does not form a democracy. That is one essential element of a democracy along with a constitution, but these two do not make a country a democracy. The heart and essence of democracy is the concept that each citizen is a sovereign in her own right, and she gives a part of the sovereignty to the state in return for which she gets the rule of law. Sovereignty is the key to this democracy. Sovereignty of a human being is the key to all human rights, I would submit, and that is what makes a true democracy. In Hindi, we use the word Lokshahi. Lokshahi means logo ki shahenshahi. All of you friends, when you interact with government, should feel like a Badshah or Begum. But that doesn't happen. And I'd like to, someone once asked me, they said, Mr. Gandhi, आप बातें तो बड़ी अच्छी चिकनी चुपड़ी करते हैं, सब बादशाह और बेगम बन गए, 130 करोड़ बादशाह और बेगम से देश चल सकता है क्या? And I'd like to give you one small example of this. In the United States of America, I'm not saying everything there is good, but in terms of democracy, they have a 2-century lead over us. Even an immigrant from any of other country, if he or she has applied for the green card, which is visa to be able to do a job there, or citizenship, he will easily pick up the telephone to ask about the status of his application. And 99% he'll get a perfectly rational answer from the other side of the telephone because a human being is called. You are all first-rate citizens of India. If you applied for change of address in your ration card and you don't get a response, none of you will think of using the phone to ask. Even if you go to that office, your chances of getting information are 50-50. That is what a true democracy is, respect for the individual. And that is what RTI indirectly does, get empowerment and rights for the citizen and respect for the citizen, apart from information. If we are the rulers of this nation, the nation belongs to you, each one of us, individually. One young student once asked me, he said, Mr. Gandhi, if the nation belongs to me and the government I own, can I take a car away from a government that if I like? I said, you can't. He said, why not, sir? If I own it, why can't I take it away? The reason is very simple, because it's in partnership with 130 crore other Indians. But, and this is important to understand, all the information on the computers, on the cupboards, on the files, also belongs to each one of us. And if we are given a copy of that, we do not deny anybody his or her right. Therefore, the default mode is information belongs to us and is part of a fundamental right. Now, I'll share a small presentation with you to give you the elements of the law. And this is a very simple law to understand. Anyone can. You don't need to be a lawyer. If you are a lawyer, of course, you have a small advantage. But any average person can understand this law and implement it. I'll show you the provisions of this law just a minute. Is my presentation visible?
Yes.
Can someone answer?
Yes, sir. Yes, sir.
Thank you.
Yes, sir.
Right. Right to information, I call it a path to Swaraj. It empowers you, and also the Swaraj that we dreamt of when Lokmanya Tilak made an announcement that Swaraj was a Janma Siddha Karani Tomi Medanaras. That is the road to Swaraj. And when we get our rule, then that is a true democracy, and that is what we shall all aim to arrive at. Let's look at the preamble of this law. Whereas the Constitution of India has established democratic republic, and whereas democracy requires an informed citizenry and transparency of information, which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to the governed, and whereas revelation of information in actual practice is likely to conflict with other public interests, including efficient operations of the governments, optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. And whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal, Parliament was aware that there would be some conflicts between what was assumed to be public interest and efficient operations of the government and transparency. These have been harmonized in this law. And in 2005, 12th October, it was Vijayadashmi incidentally. So today, as per the Indian calendar, today is the 15th year completion, and we are talking about the Right to Information Act. What is information? Information means any material in any form which is all given there. But the simple thing to understand is information must exist. It is right to information, not right to interrogation. So if you say, what is the meaning of this law? If I apply for a job, will I get a job? Why did you do this? If there is something on record available, information, that is information, and that has to be given to you. But if there is nothing on record, a PI is not expected to answer queries raised by you or go and locate an answer for you which does not exist on records. It's right to information, not right to interrogation. It's extremely important to understand. I've seen people using RTI for 10 years and not understanding this fundamental difference. Who has to give information? the law defines public authorities. Section 2H of the Act says public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, by any other law made by state legislature, by notification issued or order made by the appropriate government. A, B, and C effectively cover everything that we call government. Local government, municipal corporations, panchayats, state governments, central governments, also institutions created by Act of Parliament or state legislature. For example, the Sikh Gurudwara Prabandhan Committee has been set up by an Act of Parliament. Therefore, it's a public authority. By notification issued or order made by the appropriate government. All deemed universities, for example, are created by a notification issued by the government and therefore are public authorities and are liable to give information under RTI. And includes any body owned, controlled, or substantially financed. Non-government organizations substantially financed directly or indirectly by funds provided by the appropriate government. The PMKS fund has been a bit of controversy recently. The PMKS fund is clearly controlled by government. The chairman and 3 trustees of the fund are the Prime Minister and 3 ministers of the Government of India ex officio. They hold that position because they are ministers in the government. Therefore, they control the PMKS fund. And to claim that they do not do it as behalf of the government would be a slur on their integrity. They do, and it's very unfortunate that they are refusing to give information under RTI, which is not as per the law. What is right to information? Right to information means the right to information accessible under this Act, which is held by or under the control of any public authority and includes the right to inspection of work, documents, records. You can inspect documents, you can inspect government files, records. You can also inspect work. For example, you could ask for an inspection of a road if you believe the road is of bad quality. You can ask for inspection of a building if you feel that violations have been occurred there. One young boy from Veera Bhayandar, Krishna Gupta, he decided he wanted to inspect a government hospital. And he went and inspected it and found that some of the costly equipment that should have been there was not there, and changes have occurred after that. Taking notes, extracts, or certified copies of documents or records, this is what is normally done, taking photocopies or extracts or notes from government files. Taking certified samples of material, you can also take samples of material. For example, if you believe that the government hospital has got fake medicines or substandard medicines, you can take samples and get them tested. You can take a sample of a road core also and get it tested. Obtaining information in the form of diskettes, floppies, tapes, etc., etc. CCTV footage is also included and can be a very vital source of information since we have CCTV now in lots of public places. The shortest section, section 3, is the most important one. Subject to the provisions of this Act, all citizens shall have the right to information. Who can get the right to information? All citizens of India. Can any information be refused? This is worth understanding. Can they say this is confidential information, therefore we will not give it, this is sensitive, therefore we will not give it? The answer is no. You own the information, the default mode is all information belongs to you and must be given to you. However, some information is barred from being shared, which is given in section 8.1 of the Act, which we'll deal with, and section 9. Section 9 deals with copyright. So for example, if you ask for a DVD of a film from the censor board, they would not give it to you because it would infringe their copyright. Section 8.1 has exactly 10 subsections, and we'll look at it. Apart from that, all information belongs to you. Nobody can say it's confidential, it's sensitive, etc. You are the owner and somebody is refusing to give the owner what he owns. What is his right? Next. Section 4, heart of the RTI Act. Every public authority shall maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this Act, and ensure that all records that are appropriate to be computerized are within a reasonable time and are subject to availability of resources computerized and connected through a network all over the country on different item systems so that access to such records is facilitated. This should have happened. 15 years since the Act has been passed. The whole concept was that most information should be available on websites. Citizens need not ask for RTI, right to information applications. You are the owner, you are the sovereign of this nation, you are the Badshah or Begum. You should get information without even asking for it. Unfortunately, this has not happened. And this will really and truly happen when government working goes completely computerized, which is very easy to achieve, and there's no problem at all. Having paper files and working on paper files is creating a lot of inefficiency and is giving rise to a lot of corruption also. There are 17 points specifically mentioned in the law, which is the heart of the RTI Act, unsatisfactory implementation. Computerization is key to it, and working only on computers through e-files would actually make India a far more efficient government and ensure that transparency becomes an easy default mode. Proper implementation could improve working efficiency. It could also make the PIO's job easier. Over 50% of the RTI applications seek information which should be available under Section 4. Fair enough. I have understood what is a public authority. I have understood what is information. Who do I ask for information? Who will give it to me? The law says every administrative unit of a public authority, every administrative unit has to appoint a public information officer. You don't have to figure out who it is, what's his designation, what's his name. You don't need to know. You send an RTI application to the public information officer at the office, administrative office of any public authority where you believe the information might be. Believe. What happens if the information is not there, not with the particular person? If it's within the same department, he's expected to obtain it and give it to you. If it is with a different department, he cannot return your RTI application because you are the sovereign citizen of this nation. You own the government. He must transfer it within 5 days to the right department and inform you about it, and the right department should give you the information. There is a small token fee of 10 rupees which has to be paid with the application, and if information has to be provided to you, normally the charge is 2 rupees per page. This applies to Maharashtra government and central government. Some states have different rules in terms of fees, etc. There is no form required. Any plain piece of paper is your form. Some states have formats, so it's useful to follow the format. Some states have no formats. Request for information. A person who desires to obtain any information under this Act shall make a request in writing or through electronic means in English or Hindi or in the official language of the area in which the application is made. Therefore, let's say in Maharashtra, it would be Marathi, English or Hindi. In Tamil Nadu, it would be Tamil, English or Hindi. The response will not necessarily be in the language of your choice. It can be in any one of these 3 languages. The response will be in the language that the office is using or the information is available in. An applicant making request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. You need to give no reasons. You are the owner. In your house, if you have a cupboard, you can open it 100 times. You don't have to give anybody reason or seek permission. No locus standi is required. No reasons are required. You own the information. And it's worthwhile understanding this is a fundamental right under Article 19(1)(a), which includes freedom to speak, freedom to publish. If you have to give reasons for seeking information, you'll be asked to give reasons for speaking. You'll be asked to give reasons for publishing anything. Therefore, this is a fundamental right of citizens, and nobody can ask you, why do you want this information? It's up to you to decide what information you seek. On receipt of a request under Section 6, PIO shall expeditiously as possible, in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed, or reject the request for any of the reasons specified in Sections 8 and 9. The only reasons for refusing information are those given in Section 8 and 9. Nobody can say this information cannot be given unless he can give you a reasoning within Section 8 or 9. The 2 rupees fee that has to be paid per page. Supposing the information that you seek is 100 pages, the PIO will send you a letter saying, please pay 2 rupees per page for 100 pages, just 200 pages. After that, the information will be given to you. And I'll explain how the 30-day clock works. If PIO fails to give decision in the request for information within the period specified under subsection 1, which is 30 days, the PIO shall be deemed to have refused the request. And that means you have to be given the information without any further fees. Even if it's 1,000 pages, he cannot charge you 2,000 rupees. He would have to give it to you free of cost. PIO must give details of further fees representing, which is what I explained. Person making request for information shall be provided the information free of charge where a public authority fails to comply with the time limit specified in subsection 1, which was 30 days. 30-day period, I thought I would explain in simple terms. PIO receives RTI application is day 1, when the office receives. After X days, PIO sends letter asking additional fees. 30-day clock stops. Additional fees paid, 30-day clock starts again. Information sent after Y days, X plus Y less than or equal to 30 days. If RTI application is transferred, it would be 35 days because they get 5 days to transfer an application to the right department. RTI is a fundamental right of citizens under Article 19(1)(a), which guarantees freedom of speech and expression. Various Supreme Court judgments have held that this includes the right to information and the right to publish. Pause for a while. We say media is a very important pillar of democracy. Why is media so important? There is no specific mention of media in the Constitution of India, but it is included under Article 19(1)(a). The importance of media is because it is a medium through which the citizen gets the citizen's information. It's a medium for the citizen to get informed. Therefore, if my right to information is the reason for media's importance, my right to information is as important as the media's right to publish. Any restrictions placed on a fundamental right have to be mentioned in the Constitution. Article 19(2) says the only permissible restrictions are given in Article 19(2), which permits reasonable restrictions in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. These are covered by Section 8(1) of the Act. Beyond that, no information can be denied to you. Exemption from disclosure of information. Section 8(1) has exactly 380 words. This you must understand. This is the only information that can be denied, and reasons have to be given how the section applies. Section 8(1). Notwithstanding anything contained in this Act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relation with foreign state, or lead to incitement of an offense. To give a very simple example, the Indian Army is a public authority as defined in the RTI Act. But if you ask the Indian Army to tell you how much ammunition and how many forces are in Galwan Valley and other border areas with China or with Pakistan, this is information that will be denied to you because of Section 8(1)(a). Anything that affects the scientific or economic interests of the state also would be denied. Information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. Quite often, people refuse to give information, PIOs, saying matter is sub judice. 8(1)(b) does not cover sub judice matters. Sub judice cannot be a ground for denying information to the citizen. What the law says is information which has been expressly forbidden to be published by any court of law. Therefore, if somebody denies information saying that it's covered by 8(1)(b), ask for a specific order of a court or tribunal stating that that information cannot be disclosed. In the absence of such an order, the information has to be provided to you. Sub judice is no ground for denial of information. 8(1)(c). Information, the disclosure of which would cause a breach of privilege of Parliament or the state legislature. What kind of information is this? For example, the budget has to be presented to Parliament or state legislature. Before that, the budget papers cannot be given to you. Similarly, commissions of inquiry are set up. And as per the Commissions of Inquiry Act, within 6 months of giving the report to the government, it has to be placed on the floor of the legislature or the Parliament. Before the 6-month period is over, it cannot be given. But after the period of 6 months is over, even if it has not been placed in Parliament or state legislature, it has to be given to you because then they cannot claim breach of privilege. They've already breached the privilege of Parliament or state legislature. D. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position of a third party. unless a competent authority is satisfied that larger public interest warrants the disclosure of such information. We will deal with the public interest clause in section 8.2 a little later. So let's focus on the first part. It should be in the nature of commercial confidence, trade secret, or intellectual property, which is information which is not normally disclosed publicly. And, the word is and, disclosure of which would harm the competitive position of a third party. Therefore, it has to be shown that it is the nature of information which is not normally disclosed publicly, and disclosing it would harm somebody's competitive position. For example, if you ask for the formulation of Coca-Cola from Food and Drug Administration, this would be denied to you because it would, in the nature of commercial confidence, and disclosure would harm their competitive interests. By the same logic, Bank of India could deny information which would hurt its commercial interests, but railways cannot claim this exemption for information relating to it because railways has no competition. Tender papers, before a tender is awarded, this exemption may be claimed, but after the tender is awarded, nobody's competitive interest can be claimed to be hurt, and hence information would have to be provided. 8.1a, information available to a person is fiduciary relationship. Now, what's a fiduciary relationship? In simple terms, people say a matter of trust. And quite often, PIOs refuse to give information saying somebody has trust in government, therefore the information was given. Wrong. Fiduciary is not merely trust. Trust is one element of fiduciary. What are the traditional fiduciary relationships? A lawyer, client, a banker, customer, doctor, patient, and so on and so forth. What are the characteristics of such fiduciary relationships? Somebody gives information to somebody with superior knowledge on a topic for his or her benefit. I give information to my doctor for my benefit, or a lawyer or a banker. That person or that body is duty bound to only use it for my benefit and cannot share it with others. But I am under no obligation not to share it, any advice that he gives to me. Also, I have a choice of whom to give it, and there is no legal requirement asking me to give the information to such a person. And I can choose my banker, my lawyer, my doctor, and I have a choice of whether to give them the information or not. There is no legal bar. Most information in government is not held in a fiduciary relationship. Then why is this clause there? For example, if I have an account in State Bank of India and you ask for my account details, it cannot be given to you because it's held in a fiduciary relationship. Or if I go to a government hospital and get myself treated, you cannot get my reports because that is being held in a fiduciary relationship. But most 95% of the information in government records is not held in a fiduciary relationship. Information received in confidence from foreign government. Note carefully, this is the only place where the word confidence or confidentiality has been used. Therefore, if information is received from a foreign government and the PIO claims that the information is received in confidence, there is no further argument. One has to accept that, and that is understandable because foreign relations will not survive otherwise. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. Any information, disclosure of which would endanger somebody's life or physical safety would obviously not be given for obvious reasons. Information which would impede the process of investigation or apprehension or prosecution of offenders. What kind of information is this? When an investigation is going on, quite often PIOs refuse and say 8.1x exemption clause covers this. Wrong. That is not as per the law. The law requires and has put the word impede the process. So the government officer must show how giving the information will impede the process. In 7 cases out of 10, people who are asking have filed a complaint about something and are asking for what is the progress of such an investigation. And PIOs use this saying investigation is ongoing, therefore information shall not be given, which is an illegal denial of information. And information has to be given unless a PIO can show how giving you and the complainant is unlikely to impede the process of investigation. Cabinet papers, including records of deliberations of councils of ministers, secretaries, and other officers, provided that the decisions of councils of ministers, the reasons thereof, and the material on the basis of which the decisions were taken shall be made public after the decision has been taken and the matter is complete or over. Look at this carefully. This is a unique exemption. Up to a certain point, the information is exempt, but after a certain point, the onus is on the government to make the information publicly available. For example, if a bill is being discussed, the government decides it wants to present a bill in Parliament, the discussions and the findings and communications cannot be given until the decision is taken. Once the decision to table a bill in Parliament is taken and the bill is presented in Parliament, the government must disclose the reasons, cabinet notes and all communications to public on its own. The whole concept of democracy is that within 7 days, this information should be available with citizens so that while Parliament debates the passing of a bill, citizens also have a right to know and a right to intervene and give their own suggestions, their own comments as to whether such a bill should be there or not. That is really true democracy. 8.1J is the most popular exemption which is used by PIOs. 8.1J, information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual. The larger public interest override, as I said, we'll talk of later. However, this has a proviso. Provided that the information which cannot be derived to the Parliament or state legislature shall not be derived to any person. Let's look at this a little carefully. Information which relates to personal information. What is personal information? Any information relating to a natural person is personal information. Your name is personal, your age is personal, a letter that you write is personal. Anything identifying a natural person is a personal information. But personal information has not been barred. The disclosure of which has no relationship to any public activity or interest. Most information on public records is a consequence of a public activity. Your private letters to your friend or your parents or your dad are not public information and are not available on public records. Or would cause unwarranted invasion of the privacy of the individual. Now, what is privacy? I would submit, if you look at Article 19.2, there are only two words that relate to privacy: decency or morality. So if disclosing some information is violating decency or morality, it should not be given to a citizen, it should not be given to Parliament also. Therefore, anyone who refuses information under 8.1J must say that this is personal information, whether it has relationship to public activity or interest, or does it cause unwarranted invasion of the privacy of the individual. Now, these are slightly difficult to determine, and therefore Parliament gave an acid test to this provision, provided that the information which cannot be derived to the Parliament or a state legislature shall not be derived to any person. Therefore, anybody who denies information claiming exemption under 8.1J must make a statement that he or she would not give this information to Parliament or state legislature. Therefore, he is claiming exemption under 8.1J and therefore not giving it to you. We have public information officer, first appellate authority, information commissioner or judge who claims exemption under 8.1J must necessarily make such a statement for it to be legally correct. 8.2, notwithstanding anything in the Official Secrets Act nor any of the exemptions permissible in accordance with subsection 1, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. There is no public interest required to be shown for getting information. However, if one of the exemptions of section 8.1, A to J, cover the information, you could still argue that there is a larger public interest in disclosure. To give an example, if you ask Punjab National Bank for Nirav Modi's account details, they would probably refuse the information, saying they hold it in a fiduciary relationship and hence section 8.1E applies. However, you could argue that a major fraud has been committed and therefore there is a larger public interest in disclosure. Public interest needs to be shown only if and when an exemption applies. Otherwise, you don't need to show any public interest. You need to give no reasoning whatsoever for asking for information. Section 19, appeal. If no response, incomplete information or wrong information received, File first appeal to first appellate authority within 30 days. How do I find out who the first appellate authority is? Let's go back. How do I even find out the PIO? If you're sending it by post, address it to the public information officer in that office address. The law requires that when the first public information officer informs you or refuses to give information or communicates with you, he should inform you of the details, name and designation of the first appellate authority, who's an officer senior in rank to the public information officer in the same department. If he does not tell you what do you do? Simple technique is address it to the first appellate authority, care of public information officer, and right below that the law requires the PIO to give me the details of the first appellate authority. Since he has not done this, he must now give it to the first appellate authority. The first appellate authority should decide in 30 to 45 days. The law actually says 30 days, but he can give reasons extended by 15 days, so effectively 45 days. If result of first appeal not satisfactory, the file second appeal to the commission within 90 days. Section 19(5) says, onus on PIO the denial of information was justified. In an appellate hearing, you do not need to give any reasoning why you want information or give any reasons. The public information officer has to justify denial of information. If he cannot justify that, information has to be provided to you. Section 20 is the teeth of the Act. This is the reason the Act works. If information denied without reasonable cause, Commission must penalize the PIO at rupees 250 per day of delay after giving an opportunity of explaining. Maximum penalty of rupees 25,000. Commission can also recommend disciplinary action against the officer and compensation to be paid to the applicant. This is the reason why PIOs are worried or scared and give information and do not play lethargically. Information commissions do levy penalties. As an information commissioner, I had levied penalties totaling 98 lakh rupees on various government officers for default in providing information. But most commissioners are extremely stingy about levying penalties, and that is why, to some extent, the Act's efficacy goes down. Commission can also recommend disciplinary action against the officer and compensation to be paid to applicant. Sections 22 and 23 are also very important. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act and any other law for the time being in force, or in any instrument having effect by virtue of any law other than this Act. Effectively, Section 22 overrules all other acts and rules as far as giving of information is concerned. Most acts have this problem. There are other acts, and therefore it's a question of deciding between which overrides what. The RTI Act categorically mentions that this Act shall override all earlier acts as far as giving of information is concerned. Therefore, nobody can say that banking law says this, company law says this, RBI rules say this. Not an issue. RTI Act overrides all these. No court shall entertain any suit, application, or other proceedings in respect of any order made under this Act, and no such order shall be called in question otherwise than by an appeal under this Act. The final appeal lies with the Commission. This law specifically states that there is no further appeal. However, High Courts entertain challenges to Commission's orders under writ jurisdiction. My own view is that writ jurisdiction has certain limitations. Unfortunately, a lot of times the courts overstep that limitation and treat anything that comes to them as a writ, which I think is not as per the spirit and letter of the law. Appeals. RT application information should be obtained in 30 days. If no information provided or unsatisfactory response, first appeal to be filed within 30 days of response or 60 days in case of no response. First appellate authority, order after hearing within 45 days. If unsatisfactory order or no response, second appeal to Commission within 90 days. This is a format for Maharashtra. This is a very famous story. This was a boy who had come from a village in Vidarbha to Mumbai looking for a job. Where did he stay? He stayed in a jhopda with his chacha. While he was going around, he heard of a RTI workshop. He sat down there, understood everything, understood that any plain piece of paper will do, understood that he needs to pay 10 rupees, understood that he must address it to the public information officer, and that information is what exists. He moved on. Then he got a job and then he needed a ration card. So he went to the rationing office, gave his application. As he was going out at the door, the peon stopped him and said, "Do you want a ration card?" He said, "Yes, that's the reason I gave the form." The peon said, "Chai pani lagega." The boy said, "ठीक है, आपको चाय पिला दूंगा." The peon said, "चाय पिलाने की बात नहीं कर रहा हूँ." The boy said, "What do you mean?" He said, "You'll have to pay 2,000 rupees, only then will you get your ration card." This boy, without batting an eyelid, said, मैं घूस नहीं दूंगा. I shall not give a bribe." The peon shrugged. This boy went away, found out from the basti that people were paying bribes and getting their ration cards in about 45 days. He waited 3 months. After 3 months, he gave this application. I'd given an application for a ration card in 5th August 2006, photocopy of receipt attached. I want the following information about its progress in the following format. Date on which application received, name and designation of the officer receiving it, action taken, date on which forwarded to next office. I want a list of ration cards issued in the last 2 months, giving the dates on which the applications were made and the dates on which the ration cards were issued. What could they respond? They could not say it's not moved at all because chai pani nahi diya. So next day, the peon came to his house and said, "The rationing officer has called you." He went there. As soon as he went, the rationing officer said, "अरे इनके लिए कुर्सी लेके आओ और इनका राशन कार्ड ले आओ और एक कप चाय और एक गिलास पानी लेके आओ." He did not give chai pani, he got chai pani instead. And then 1 cup of tea, according to me, respect for the sovereign Indian citizen. That is what it does. Gets you what is on record, gives you accountability, helps you stop corruption, and makes you an informed and empowered citizen. This kind of information requests have been made a number of times for water connections, for ration cards, for not getting rations, for income tax refunds, and so on and so forth. This is another story that I'd like to share with you. This was on one day I saw advertisement on page 1. There was a big photograph in Times of India of citizens who were demonstrating at Marine Drive because the police constable More had raped a minor. On the same day, on page 5, I saw a small news report, and that led me to this RTI application. According to a news report in Times of India dated 29th April 06, Inspector Prakash Avre was accused of raping a minor girl in September 2005. This was a report on page 5 of Times of India on that day. He was acquitted by the Sessions Court in February and was being reinstated in service. They could not prove the guilt, therefore he was being reinstated. I want a photocopy of the order reinstating him along with the life file notice based on which the decision was taken. PI refused to give this information. Therefore, I filed the first appeal, which I am sharing. I had asked for information regarding the reinstatement of Inspector Prakash Avre as per the attached application. The PIO first sent me a letter saying the information should be provided by Bhaikala Police Station. PIO Bhaikala replied by his letter of 16/5 that the information could not be provided as it was exempt under Section 81H, which exempts information which would impede the process of investigation or apprehension or prosecution of offenders. Grounds for appeal. PI has not shown how providing the information could impede any investigation. In fact, no investigation is being held since Prakash Avre has been reinstated. The rejection is without any basis of law. I went for the first appeal hearing. The Deputy Commissioner of Police was there. He was a very good officer. He said, "Mr. Gandhi, what could we do? Look, court has let him off." I said, "Sir, from my perspective, I'm only asking for a record of what grounds have been mentioned. From my perspective, there are two possibilities. Either Prakash Avre is guilty of the crime he's alleged to have committed and has been let off, in which case reinstating him is great disservice to the police force as well as to the citizens. Alternately, Prakash Avre was innocent, in which case somebody framed him. He should be held responsible. This cannot work like this." He saw the point. He said, "Let me see what I can do." In 20 days, I got an edict from the Mumbai Police Commissioner's office that Police Inspector Prakash Avre had been dismissed from service. That is the power of right to information that any one citizen sitting anywhere can do. One little girl of 10 can ask for information under RTI and therefore get accountability and respect and empowerment from the government. This is the key thing of the right to information. My submission to all of you is, consider using this. According According to a survey of mine, all Indian citizens script for at least 2 to 3 hours every month about what is wrong with India, and the government, and the ministers, and the police, and the municipal corporation, etc., etc. Does it cribbing change anything? It changes nothing. It can change nothing. My submission to you is, if it's good for your mental and physical health, continue cribbing. Half an hour out of that, decide to send an RTI application on an issue that concerns you, on an issue that you are cribbing about. Look at it as your duty towards the nation. If you do that, here's a dream I want to share with you. If 30 lakh Indian citizens do this once a month, every month, as a matter of duty to the nation, 3.5 crore RTI applications will be filed in a year. Not every RTI application results in some result, but according to my assessment, about 30% of the times, something changes in the government. Some small change occurs, 30%. The rest, 70%, nothing changes. If 30% change occurs, if 1 crore times a small change occurs in the government of India and the governance, in 10 years' time or 5 years' time, India would be a different nation, which would be a true democracy, responsible, accountable to the citizens of India. One last thing I'd like to tell you is, today is Vijayadashmi. Take this vow today. DIYA has made a great initiative of sharing knowledge with everyone. Use this knowledge. And it is up to you to change the nation. Nobody else will. One old gentleman, one of my talks, got up and said, Mr. Gandhi, मैंने बहुत ट्राई किया, कुछ होता ही नहीं है, इंडिया में कुछ होने वाला ही नहीं है. मैं 10 साल तक कंप्लेन किया, RTI लगाया, कुछ नहीं फर्क पड़ा. To people like that, I say, many of us go to mandirs, masjids, gurudwaras, churches, agyaris, derasars, once a day, once a week, once a month, maybe once a year. When we go there and come out, what happens? Do we get an extra 100 rupee note in our wallet? The answer is no. Why do we do it? We do it as an act of faith. We have faith that by doing this, something good will happen to my country, my nation, my group, my city, myself. We see no logical connection. We do it as an act of faith. What do we do for the nation as an act of faith? My submission to all of you is, try this as an act of faith for the nation. You are the Badshah or Begum of this nation, and you have the responsibility. Being a king of a nation or sovereign of this nation is not just authority, it's also responsibility. If things are not right in the country, you can change them and only you can. Here's a slogan I'd like to share with you. Mera Bharat Mahan, we say, a lot of us, and we don't really believe it, do we? Therefore, I say, Mera Bharat Mahan nahi hai. Mera Bharat Mahan nahi hai. But ye dosh mera hai. I, the individual sovereign citizen of this nation, am responsible. I will change this nation. Nobody else will. Thank you very much. Thank you.
Thank you very much, sir.
You can stop the sharing.
Yeah, you can. That was an amazing information, Max, and such short in what are the remedies in case of information not being provided, etc., and the appellate remedies as well. So many of us who do not understand the intricacies of the legal system of our country are perhaps not aware, but you, in a very simple language, explained it all. And thank you very much for that, sir. So we have some questions from the audience, some very common questions that we usually have. I mean, despite the presentation, there are certain practical questions that we are faced with when we actually make an RTI application. So in that context, my first question, sir, and we have selected questions from the audience. The first question is, when we speak about using RTI as a tool to get information and for something constructive, but it's often also used as something which is not in a right sense. it's misused, so to say. So how does one sort of deal with such a problem, and where to draw the line of how to use?
Explain it like this. Everybody in power dislikes RTI, and therefore a very strong negative narrative is being built. Let's look at Article 19(1)(a). When I speak, I can make an allegation against somebody. Okay, it can hurt him or her to some extent. When I publish something, I can do greater damage. When I ask for information in RTI, what can I do? I can only ask for information that is on record. So what is misuse? If the record shows that somebody has done something wrong, he needs to pay for it. And I'm aware that a few people, very few, use it to blackmail people. But let's understand the concept, what's happening. Somebody is doing something wrong, he's like a thief. There is this blackmailer RTI user who uses RTI to blackmail him, get information and blackmails him and picks his pocket. What kind of nation are we? We are not concerned with the thief. We are more concerned with the pickpocket. I think this misuse thing, if there is misuse of RTI, there is misuse of freedom of speech, there is misuse of freedom to publish. Everything can be misused, but RTI misuse is very little compared to others. But this strong narrative is being built because everybody in power dislikes RTI. It is changing the whole power equation in the nation.
Right. Another question that has come is, I mean, with COVID, we have seen our schools going virtual, and space, and everything is happening.
Your voice is cracking, my friend. Your voice is cracking.
Yeah. So with the onset of COVID, we have seen courts and tribunals going online. We are all appearing before courts in virtual hearings. And the online mechanism has, in fact, become the order of the day invariably. So is there any mechanism where one can file an application online, and there is a grievance redressal mechanism of RTI applications online? Or are we still a long way to go on that front? Shouldn't government departments take it on their own to make the system online and dispose of RTI applications online?
Maharashtra government, since about 2 years, has an online facility for RTI applications. The central government also has. Some other states have got RTI online, some don't. But we are working towards that. And we had asked the Maharashtra Commission also to start functioning online virtually. And now we have a PIL in Bombay High Court. The government has considered that all quasi-judicial bodies must do virtual hearings in RTI and non-RTI. And we are trying to persuade the court to issue orders saying that even after COVID, virtual hearings should continue.
Right, sir. So the next question is, in your quest to segregate information from interrogation, the spirit of RTI gets lost. I mean, it's more or less on the same lines what we discussed. As authorities get excuses to avoid sharing of information, how can spirit of RTI be upheld and promoted after considering sections 8.1, 8 clause 1 and 9 of the RTI Act? How do we retain the spirit of...
This is a tough one. What we need to do is we need to get better commissioners. We need to look at... RTI is today at a cusp. The judiciary doesn't like RTI, the political class doesn't like RTI, the bureaucratic class, because nobody likes to give up power. We as citizens must build pressure, and that's happening. In fact, very incidentally, there are lots of RTI groups across the country meeting virtually every week. They have used this as an opportunity to get together, to discuss, to debate, and so on. We need more people to use this. If we can get 1 crore citizens engaged in RTI, not fully, spending 1 hour or half an hour in a month, I think we'll go towards a better democracy. We'll have to build public pressure. That's the only way we'll be able to get a change. I think.
Sir, one question now that we have spoken about information which is sensitive, which is at times confidential, etc. Do you see any interplay between the RTI Act and the PDP bill, the Personal Data Protection Bill? Whenever it's enacted in future, will there be any sort of an interplay between the two, or would there be any conflicting sort of situation between the two statutes?
The first draft of the bill suggested by the Shri Krishna Committee had actually asked for an amendment to the RTI Act, Section 81J. However, the bill that is presented to Parliament has removed that clause. So logically, it should not impact, but we'll have to see how the final act plays out. It's the truth really is, I think we need greater RTI and greater transparency compared to personal protection. These are concepts that are useful for the Western countries, which have moved far ahead on the democracy front. We have a lot of corruption, we have a lot of misgovernance. And I personally feel we should err on the side of transparency at this stage of our democracy. 20 years from now, maybe the story could be different.
A very pertinent question, and in fact, it has sort of been asked a lot of times about political parties, and any political party for that matter, whether they should come within the ambit of RTI. What is required, as you rightly said, whether we need to build more public pressure or a public sentiment to force the political parties to bring themselves under the ambit of RTI.
The truth is, I look at it not what should happen, what the law says. The law says any institution substantially financed by government is a public authority. 6 political parties, the Central Information Commission has ruled way back in 2012 or 2013, that 6 major political parties are public authorities as defined in the law. The matter was before them. These parties included Congress, BJP, NCP, the Communist parties, and the BSP. Now, funny thing has happened. They've not challenged this decision in a court, but have just said, like, we will not follow the law. And when 6 major political parties don't follow the law, how do you get implementation of a law? But as you rightly pointed out, we need to build public pressure on them. Without democratic working and without transparent working of political parties, we will not really achieve transparency. This is also a cultural issue. We need to get this in our bloodstreams, that we need to be transparent, that it's good for the nation, good for individuals, good for everyone.
As you rightly mentioned during your presentation, sir, that the law provides for digitization of data, but there is a logistical issue. In storing of this data in physical form. How do you think we can practically achieve this? Is this practically possible, given the quantum of the sheer volume of documents that we have in public offices? Is it possible to achieve this goal so that everything?
While I was an information commissioner, for the last 2 years, I operated a paperless file, or paperless office. And if that happens, look, it's quite simple. Relevant files which are current need to be digitized, not everything. What they are doing is they are digitizing everything. And new files that are open should be only dealt with electronically, and the paper consumption should be drastically cut down. Just understand, when you have a paper file, you can alter records, you can change records, you can burn the files, you can steal the files. On electronic files, these things are not possible because you can have a backup in some other place. And if somebody makes a change, that person can be caught, and what it was before that can also be identified. 30% of India's corruption would disappear if we dealt with it electronically. There is no hitch. It's just the will to do it has been lacking, and people are not demanding it. What could be the problem? Tell me. Let's anyone discuss.
Uh, and what do you think? How can we sort of achieve a sensitization of AI? Of course, webinars like these are helpful to address a particular audience and make them aware about what the law is and what can be the steps that they can take to do their bit as a citizen. But how do you think we can increase the sensitization? And because it's a very powerful tool, it's a very powerful tool, and if, as you rightly said, if the citizens can become aware of what it exactly is and are aware of how to go about it, then I think a lot can change. But what can we do on the level of sensitizing people about RTI?
One thing is, if you use it yourself, you start becoming. This is an extremely simple law of 31 sections, and as I said, the most important are 380 words of Section 8.1. Apart from that, all the information is yours and must be given to you. Start using it. The best way is begin to use it. If you start beginning to use it, you will be able to figure out how to deal with this and teach others. And this citizens have been doing it across the country. Free of government has not promoted this act. Citizens have been promoting it across the nation. And young people like you, if you take to the RTI Act and say, I'll file one RTI application once a month on an issue that concerns me or an issue that is public cause, within a year, you will develop the skill of explaining and teaching others, and a lot of this is happening. We need young people, especially ladies. Ladies are not using RTI very much, women, for some funny reason that nobody is able to figure out. I wish women were empowered also.
We spoke about and we discussed about the scheme of the act. The scheme of the act does not leave any room for denying any information if it does not fall within the exceptions that are provided in the act itself. Now, on a practical level, we see something differently, sir, because at times information is denied on one pretext or the other. How does one tackle this? Of course, in addition to the process that is there in the act, how do we practically deal with the situation where an information is simply denied by saying it is confidential or it is likely to cause harm to the integrity of the country? How do we tackle such a situation?
See, we should get better commissioners. The truth is, we don't have, on the whole, I'm not saying all commissioners are bad, but on the whole, information commissioners are not very good. They are not committed to their work. And this applies incidentally not just to information commissioners, it applies to a whole range of such authorities. Human Rights Commission, Women's Commission, Minorities Commission, Lok Ayog, all these arbitrarily selected. No accountability. We need, therefore, we as people need to put pressure on all these bodies, which are our checks and balances of democracy. We are not doing that. We have been slightly lazy citizens. We just crib. बैठ के अरे ये ऐसा है वैसा है वैसा है. Let's begin to start believing we need to do something. Nowadays, there's a lot of talk of patriotism and nationalism. I would submit that patriotism is not merely standing up when the national anthem is being sung or saluting the national flag. It is wanting to change this nation for the better. It is feeling that fire in the belly that I must change and only I will change it. Nobody else is going to come and change it. Only you and I and the young people will manage to change the nation.
Absolutely, rightly said that we as citizens and we as young people need to become accountable to ourselves and to the nation as such, and ensure that we take that first step and others can follow us. So on that note, thank you so much, sir, for joining us today and providing deep insights on this law, which is very simple and it is something which is great for citizens, but people do not, because of lack of, perhaps technical knowledge or rather the zeal to do something, are not able to sometimes grasp. But thank you for presenting it in a very simple manner for people from all walks of life. Um,
minute? Before I'd like to end this with a small story. A lot of times people feel मैं individually क्या कर सकता हूँ, मैं कुछ नहीं कर सकता हूँ. 5,000 years back, on an Amavasya day, people were at the beach watching the sunset. They saw the sun setting. It's a lovely sight. You get various colors, yellow, orange, blue, cloud wafting through. They saw the sun going down at the horizon, down. And then just the last rim of the sun was left. Everybody said in the next 2 or 3 minutes, the sun will set. 2 minutes, 5 minutes, 10 minutes, the sun did not go down. People panicked. They thought it's the end of the world. They started running helter-skelter. One young girl of 6 picked up courage and asked the sun, said, Lord, why are you not sitting? We are worried that the world may come to an end. And the sun said, today is Amavasya. And I am worried today because once I said there will be complete darkness. There was a little lamp, a diya like yours, which had some oil in it, and said, Lord Sun, give me your spark, and if I light up, there will be one lamp. And even if one lamp lights up, there cannot be complete darkness. The sun gave the spark to the little lamp. The sun set. And this little lamp gave its light to lots of other lamps. And that was the first Deepavali. Happy Diwali to all of you.
Thank you so much, sir.
Thank you, sir. Thank you so much, sir.
And on that note, I would like to thank all our support organizations which have to the Gyan Sabha success. I would request the participants to bear with me for a couple of minutes and keep themselves on mute so that I can sum up. Yes, sir. Thank you so much, sir. And I would like to thank all the organizations who have supported us in this endeavor to bring to you this session of Gyan Sabha. And sir, I would also take this opportunity to invite you to the Dev Sanskriti University at Haridwar. Once this pandemic is over, you please visit there and see for yourself that activities of great change are taking place.
Sure. Thank you. Thank you. Thanks to all of you.
Yes, sir. Please do join us, all the participants, every Sunday at 4:30 as we bring to you another participant from another field to enlighten you and to take up a topic which impacts our lives and which impacts us as citizens of this country and which impacts our overall well-being and the quality of life that we lead. So please do join us on the next Sunday as well. In view of this pandemic, ये जो कोरोना की महामारी आई है, हमने हर शाम को 6:20 से 6:30 कलेक्टिव गायत्री मंत्र चैंटिंग का एक ग्लोबल मूवमेंट चलाया है. So please do join us, global prayers from 6:20 to 6:30 wherever you are. Chant Gayatri mantra or whatever you think is the best mantra for you. In simple words, the power of collective prayers is immense, and if all of us pray with all our might to the Almighty that this problem goes away, then I'm sure it will go away. So I do hope that all of you will join with us in the global chanting of mantras from 6:20 to 6:30 every evening. Keep joining us and do give your feedback. We have shared feedback from the chat box. And that's it from us for now. And I would request everyone to please keep themselves on mute and join me in doing the Shanti part. Om Jo Shantirantarikshakum Shanti Prithvi Shantirapah Shantiroshidaya Shanti Vanaspataya Shantir Vishvedeva Shanti Brahma Shanti Sarvagam Shanti 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 Om Shanti 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 Sarvarishtasu Shantir Bhavatu. Thank you for joining us.